The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
Hi everyone, welcome to another edition of Eye on Oshkosh. I'm Cheryl Hentz along with my co-host Tony Palmeri. On this edition, what we're going to do is, we know that the Five Rivers thing is, history, but we have not had a chance to do a show on the decision from the Attorney General's office on that closed meeting that the council held from back in February. So on this particular show, Tony and I are going to talk with attorney Chuck Williams and Open Records and Open Meetings advocate Ann Frisch, just kind of doing a recap and a wrap-up on the whole Five Rivers thing, how it started with the complaint that Tony and I filed and so on and so forth. So welcome to both of you. We appreciate very much your both being here.
Thank you.
So, and I should also say that Stu Rickman from the Oshkosh Northwestern was going to be here tonight because they too had filed a complaint like Tony and I did with the Attorney General's office over that closed meeting. There was a screw up on the dates, and Stu couldn't be here tonight, but he did share some information with me that we're going to share with you all later on. So that being said, this goes back to February when the Common Council decided to hold a closed session or executive session meeting on February 14th. It was Valentine's Day, as a matter of fact. During part of that meeting, they discussed some things with developer Tom Doig over the Five Rivers situation, and then Tom left and the council continued on with their meeting. Now, Tony, you had, along with a few others, crashed that meeting.
Yes.
And you actually spoke at the meeting. Why don't you tell folks a little bit about, why you felt that meeting shouldn't be held?
It had become clear by February 14th that the city had invested much weight in Tom Doig's proposal to the point where I felt, and many people also felt, that it was a done deal. That if Mr. Doig could come up with the financing, that property was his and it was ready to be built on. Therefore, I felt, and others felt, that everything at that point should be open. Because if a council wants to go into closed session, I want to read the statute. It says, Wisconsin Statute 19.851E says, a closed session is authorized for deliberating or negotiating the purchasing of public properties, the investing of public funds, or conducting other specified public business whenever competitive or bargaining reasons require a closed session. The key point is competitive or bargaining reasons. And we made the argument that the competition was over and that there was no bargaining. And Chuck, I'm sure you've got some experience with that statute, or at least are familiar with it.
Yeah, one of the key phrases in there is the word require,
Yeah.
and whether the situation at that point required a closed session was one issue that the Attorney General's office was concerned about. The open meetings law, as we know, and maybe most of the viewers know, but a lot of people don't realize, Wisconsin has one of the strongest open meetings laws in the United States. And what does that mean? It means that the general public should have access to all government proceedings to know what is being said, so that we can be an educated electorate and elect people who are representing our interests and know exactly what they're doing. So there is a presumption that all government meetings must be open to the public, and that our open meetings law is to be liberally construed in favor of open meetings. And in the rare instances where there is an exception to the open meeting law, you can have a closed meeting. And so the Attorney General was trying to determine in this case was it a legitimate subject for a closed meeting?
Right.
The other issue is when you have a closed meeting or any meeting, you've got to give public notice as to the substance of the meeting so that the public knows whether they should come and hear what's going on. If it's going to be a closed meeting, you also have to give adequate notice of the meeting. And in this particular case, the Attorney General did have a problem with the notice of the closed meeting not being adequate, and then the actual subject matter of the closed session not being justified as a legitimate subject for a closed meeting.
Yeah, they said half the meeting was appropriate
And half
of it wasn't.
Right. And the notice for the closed part wasn't adequate in the, that, so they, but they did have the discussion apparently was over whether Mr. Doig had met his financing requirements, and if he hadn't met them, what should the council do for strategy purposes to deal with him? And I guess the Attorney General felt the strategy discussion was legitimate for a closed session,
Right.
but knowing whether Mr. Doig had met the financing, term sheet that that was public knowledge of everybody, whether that was a legitimate purpose for a closed session, and it wasn't. It was a violation to hold a closed session on that subject, and the notice they felt was not, the notice of this closed meeting they also felt was not adequate to tell the public what it was about, what they fortunately for the city officials, they didn't find that it was a situation where they would fine anybody. They can be fined if they knowingly commit a violation, and I do think the city officials involved did act in good faith, the elected officials, in going through with the meeting, but I don't know what you think about
Well,
that, but
well, we've got some strong opinions. So let's back up. So you, Tony, you and four others had actually crashed the meeting, and what happened there?
We went into the meeting and said that in our judgment this was not an appropriate closed meeting, and we were going to sit and listen essentially to the meeting. And Mayor Bill Castle said that he respectfully disagreed with our position on that. This was a long time ago now. This was back in February. I don't think he threatened to bring in the police, but we knew that it would be headed in that direction, and none of us really wanted confrontation. We wanted to make the point that there are citizens watching what government is doing and are not happy about it. So we left, and then of course you and I filed the complaint not long after, as did the Northwestern. What disturbed me, and I want to shift this over to Ann Frisch here, it took the Attorney General's office, was it 8 months?
We filed it in late February, early March, and we finally got a decision on, this was drafted, the decision was drafted on November 7th.
Yeah, so is this common, Ann, in these kinds of cases for the Attorney General's office to take this long to make a decision?
Well, it seems like a long time to me, but I think they vary a good deal. We also filed an open records appeal too, and in that case, it took them almost as long to decide they weren't going to help us out and take our side to make the city comply. And actually, by that time, the issue was dead. So there wasn't a lot of motivation on our part to pursue the records, but the state said they had already discussed this with the city, so therefore they couldn't take our side, but never mind, we'd find another district attorney to take the case by that time.
But if it takes 8 or 9 months to get an opinion from the Attorney General, and then they usually decide, well, we really can't prosecute, doesn't it mean that our open meetings law and open records law are maybe toothless tigers in a way? If they're not aggressively being enforced, Doesn't that-
Actually,
yeah.
I think that the fact that the issue arose is what helped to kill the whole project, because I think when you sat in on the council meeting, it seemed to me from that point on, people then became suspicious. And then council members felt more defensive. This is just my looking in over their shoulders. And I think that the very fact that you had to sit in there, even though it was only for a few minutes, was really what did it. Could they have made I doubt, I'm not sure they could have made a decision on this in time to stop. Let's say the city had decided we're going to go ahead with it, then you would have really been under the gun to get a decision, because then
Exactly.
possibly you could have gone back and undone it because the public really hadn't been adequately informed. But I'm not sure they always undo the decisions either.
Exactly.
Yeah, I believe the state, has the power to attempt to change the decision that was made at an improper meeting, but it's rarely done. In this particular meeting, I don't know what decision they actually made. They didn't make any formal vote on something like, let's extend his financing a longer period
Actually,
of time.
didn't that come out from that meeting?
But they did later vote to
They
extend
did later
this.
vote
Yeah, I
on it.
think that
Whether
they
apparently they didn't actually make a decision at that time. They
Right.
discussed
Yeah,
strategy on
so
what
they
they should
decided
do.
that they would
Yeah.
decide.
But
Yeah.
one of the remedies, I guess, for a violation of the law is to void what action was taken at a meeting that was not lawfully held.
Well, Chuck, let me ask you this. As an attorney, what would you recommend then? Say that things took a different course here. Say Mr. Doig somehow got some financing and he started breaking ground on this project, and we were still waiting, both Tony and I and the Northwestern, still waiting for a decision from the Attorney General's office. What recourse then would we have as complainants? Because obviously he's breaking ground, the construction is getting underway. Would we then have to expend our own personal funds to get an injunction to stop the city?
Actually, that's a good question. I believe that an individual who is prosecuting a claim such as this is acting on behalf of the Attorney General, and if the case turns out to be successful, that your complaint is valid, you can have your attorney's fees paid for by the violating party. You can have reasonable attorney's fees for having to pursue this, which is a discretionary thing with depending on the success of the whole claim. But I didn't. In reviewing this, there is that remedy where you can seek to be reimbursed for your expenses and your attorney's fees for having to bring this matter forward, and that's if you're successful. If you're not successful, then the likelihood of getting that is probably much slimmer. But it kind of depends on the facts and what the outcome of the case is. But if he had gone ahead and, a lot would depend on what was really done at the meeting and how did it influence his, going ahead with the project. Did it make any difference? And did it, but in theory, if the council made some decision at that meeting that could be it could be reversed or, voided. And that's why it's so important to follow the open meetings law. And if you go into anything you do with open meetings law, if you don't dot your T's and dot your I's and cross your T's, you're
okay.
could have your action voided.
My understanding, and this is for Chuck or Ann, is that if elected officials have any doubt at all about the appropriateness of a closed meeting, they should not go into a closed meeting.
That's right.
Now, at that meeting on February 14th, Mr. Esslinger announced he wasn't going to go into the closed meeting because he thought it was inappropriate. I spoke, another citizen spoke, we introduced at least some doubt. With all that in the mix, you've got one of your colleagues not going into the meeting, you've got citizens expressing doubt, you've got the city attorney who doesn't sound absolutely sure one way or the other what to do, how could a council go into closed session at that point? And by the way, we sent the Attorney General a videotaped copy of that meeting.
Yes, we did.
Yeah.
So that they could see what that discussion that took place.
Mm-hmm.
And I would just defy anyone to look at that council
Yeah.
deliberation and say these people were certain that this was a proper meeting. And
Well, I think it's possible that the attorney who made the decision was right. Just because it's popular opinion doesn't necessarily mean that they should just, okay, well, let's open up the meeting. But I would say it certainly would be reason to be very, very careful about closing.
I mean, what would have prevented them from simply saying, we won't go into closed session right now. Tomorrow, the city attorney should consult the Attorney General's office and find out if this is proper.
I think that would have been a good choice.
Yeah, what was, I mean,
I think they were feeling some pressure to move on and move along on
but
that
it sounded like the pressure was coming from the developer. There was no other
Very well.
pressure that I could see.
Well, I
Well,
think there
maybe
was
from
pressure to know
Department
whether
of Community Development.
Yeah.
whether the developer was going to be able to get his financing. I think was an urgency that the city, wanted to know about. But I guess in some of the council members did ask for the city attorney's opinion.
Yeah.
Which I think the attorney general said that was, that showed they were trying to comply, and so they consulted their lawyer, and he gave them an opinion that it was okay. And I think his opinion is arguably was wrong on at least part of the decision, according to the attorney general. But for a person to be fined, it's a civil forfeiture for violating the, and that's not a crime. It's a forfeiture, which is not the same as a crime, but it does have a fine. And but if a person is knowingly going ahead with a meeting, knowing it's wrong, knowing damn it, we're going to go ahead anyway. It's even though we know it's wrong, then they can certainly be fined. But if there is uncertainty and they consult an attorney that kind of their attorney, and he advises them it's okay. Their knowing violation is, not as likely.
Yeah.
But at the same time, when they, like you were saying, there's kind of a presumption in favor of an open meeting,
Right.
and when you have doubt, you should still have an open meeting. All of those kind of public policy in favor of open meetings should be followed. And
One thing that struck the citizens as odd, I was disturbed by this myself.
Yeah.
Here we were on the verge of a $60 million project, big ticket item for the city,
yeah,
and yet the developer was never going to have to address the public in any meaningful way. I don't understand how they thought that would build confidence for the project.
yeah.
Why must everything with this man be done in secret? I thought that was setting a precedent, which maybe we've already had this precedent,
Yeah.
that everything goes on behind closed doors. That's just not good government, is it?
But it's absolutely not good government. In fact, some people think that because you elect somebody, then they can go into closed session
Yeah.
for every meeting and just run things the way they want to. But I see it very differently, that we appoint people to make those decisions, but we're standing over their shoulders saying, do this, do that, oh no, don't do that. So I take a very democratic view of things, that we should be hearing all along what's going on, if we choose to listen in, and tell our representatives what they should be doing.
Now, Chuck, when the city attorney was asked about this opinion, Mr. Kraft, he made it sound like this opinion is very vague, and that the Attorney General's office doesn't clearly say that there was anything improper here. Is that a correct reading of this document?
Well, I guess that's debatable. Whether I don't think it's vague. I know there is a case pending before the Supreme Court that allows for the public notice to be rather vague. There was a case over a liquor license getting revoked or reapplied for, and all the public notice of the meeting said is it's going to be about licenses. It didn't say liquor licenses, and and the Court of Appeals, which is a lower level court, said that was adequate notice, and now it's before the Supreme Court, and they're arguing that it was not adequate, it was too vague. And so the Attorney General did say that if that case, which is before the Supreme Court of Wisconsin next month, is upheld or reversed, it could make what the city did here more. It could make it less of a violation, or it could make it more of a violation, depending on what the Supreme Court says. If the Supreme Court says that liquor license case should have been more specific, then it would make our notice in this case should have been more specific. And but they still felt that the Attorney General still said that it was their opinion that it was wrong, regardless of what happens in that case. And they, I'm trying to find the language here, but in our opinion, the closed session notice failed to adequately apprise members of the general public that the real topic of discussion was the developer's ability to fully comply with the deadlines set forth in the term sheet, particularly as they concern financing to support the Five Rivers project, and a consideration of the city's possible options that he could not comply. And no attendee claimed that any discussion involved actual ongoing negotiations for the purchase or sale of property, which was what the notice said. This closed meeting was regarding negotiating land acquisition and purchases, and it wasn't about that. It was really about, did Mr. Doig meet his financing deadlines, and what do you do if he doesn't? And so the notice wasn't quite adequate, and then the meeting itself, to be a closed session meeting, should his topic about whether he'd met his financing should have been a public meeting.
Of course.
The meeting part of it that could have been closed is what should the strategy be of the council to deal with his inability to get financing that they wanted him to have by then. But whether, I think the opinion of the Attorney General was, fairly specific, and that it did explain everything quite well, I think.
I thought so too.
Yeah.
Well, yeah, and there's a few things about Mr. Kraft's opinion on this matter that I guess I find disturbing. I mean, number one, he doesn't think it's very clear. He feels it's vague, as Tony said. Number two, he has said publicly at a city council meeting that if he had to do it all over again, he'd do it the same way. Or maybe he said that in the press, but in any event, he said it publicly that he would make the same decision again and counsel the city council exactly the same way if he were to do it again. And the third thing that I find disturbing is that this is not the first time that a citizen in this community has gone to the state attorney general and said, take a look at what the city council in Oshkosh is doing. The first one was over the bathrooms at the Leach and not getting a bid. Now, the Attorney General, while they didn't render this kind of a formal opinion, they were just told the gist of it, and they said, no, this is wrong. You have to put a project like this out for bid. The problem with Mr. Kraft that I see is he clings to the opinions from the Attorney General when it benefits the city. When it benefits the those of us who advocate for and really enjoy the freedom of open government, when it benefits us, then the Attorney General's opinion is, well, it's just another opinion. I mean, how can you go both ways with this?
Yeah, and that's the most disturbing thing about this is, we can live with this. We didn't get the project, so we're fortunate. It took a lot of effort, but I think that some of these records and meetings issues signal the downslide of this project. But what are we going to do now on the next issue, on the next meeting? And if he's still saying I would do it just the same, then I have some worries about, what were the lessons learned, and what do citizens have to do now to make sure it doesn't happen again?
They are going to apparently ratchet up their their meeting notices for closed
Yeah,
session
that should-
meetings.
Right,
that should
that was
be
a
done.
criticism that they
But,
are
It's
prepared.
still always the responsibility of the chief presiding officer, but you get in the actual process, and nobody's checking, then, it's not going to be a big death penalty case, but,
Right.
we want decisions to be made that support democracy and support openness of government, and not just the sort of legal, we did the legal thing and so we're okay. We want them to be very specific about what they're going to talk about. So we want a 5-point bulletin or 5-point bullet points on specifically what they're going to be talking about, and especially if they're going to go into closed meeting, we want to know, does that meet the test?
Exactly.
Well, and as part of the disturbing pieces here, I think you just lost your microphone, Ann.
I did.
I saw it out of the corner of my eye fall down. The other part that is disturbing is what Stu Rickman from the Northwestern was going to share with us had he been here. And that is that, again, City Attorney Warren Kraft apparently doesn't want to hear anyone's opinion unless it sort of validates his own. And I'm just going to read what Stu wrote me by email here. On February 14th, I had the Northwestern's media attorney research the law. He said there was enough doubt about the legality of the meeting and sufficiency of the notice that he would call Warren Kraft for an unofficial lawyer-to-lawyer chat. When he got Warren on the phone, he was told basically, we can't have this conversation because you have a conflict of interest. Your firm represents the city on environmental issues. He goes on to say Warren didn't even want to hear a second opinion. He went on to advise each council member individually that their attorney was going to make that call based on his belief that the meeting had been flawed. And 2 council members, Burke Tower and Brian Bain, both expressed interest in hearing what a second attorney had to say. And we're grateful for, the steps that Stu Rickman had taken. But here again, like I said, Mr. Kraft just doesn't want to hear, apparently, what anyone else has to say. And it wasn't official. It was not an official phone call. It was completely unofficial. So I'm not sure where this, conflict of interest thing comes into that. I mean, what do you glean from that, Chuck?
Yeah, I guess he was saying that that attorney's firm somehow did work for the city indirectly in the environmental area, and so he couldn't be on the other side opposing the city, for the Northwestern as their attorney. And I guess that is potentially a conflict of interest. It depends. It's on different issues, environmental, representing them on a totally different matter. But I don't know. Warren Kraft is a very competent lawyer and a smart guy, but I don't know. I wish he would be a little more sympathetic to some of these issues, and reading the open meetings law and the policy behind it and what our state wants done. I don't think there's anything wrong with being open. What do you have to worry about? I mean, it's
Well, maybe we need some more training for public officials.
Well, it could be. I know, and there is. The
state does some of it.
The state
but
does a lot. The Attorney General Office. I've even got a book here, a compliance guide that was published by Peg Lautenschlager as Attorney General, and an informed citizenry is the bedrock of representative government. In order to properly observe, participate in, and critique their government, Wisconsin citizens must be assured that the operations of government occur in the full light of day, is what she writes here, which I think is, it's a democratic concept that doesn't occur in a lot of countries around the world, but it's here, and it, why not, as the city attorney, advise, in accordance with that liberal, open policy. But there are, specific good reasons to have a closed session, that certainly are legitimate, and there's nothing wrong with it if it's necessary, and in this particular case, the exception to the open meetings, they said, was whenever competitive or bargaining reasons required a closed session, and whether this required one on all this, according to the Attorney General, it didn't require it except the strategy for what to do in the future.
I just want to read just a part of the language to show the community how strong was the Attorney General's opposition to what the city did. The Attorney General's office interviewed Mr. Kraft and Mr. Wolank to find out why did you go into closed session, and Wolank and Kraft gave their reasons, and the Attorney General says none of these reasons survive serious scrutiny. Although the contracts and other paperwork for the project were not completed, the purpose of this part of the session was for the Common Council to get a status report on the developer's compliance with already negotiated terms that previously had been made public. There is no doubt that information which revealed that the developer may not be able to comply with some of the terms is both embarrassing and frustrating. However, that is no reason for withholding the information from the public. Moreover, given the extent of the city's commitment of public funding to support the project, this is precisely the kind of information that should be in the public domain.
Absolutely.
Now, with all due respect to the city attorney, you can't be more clear than that.
No.
And to say, well, I would give the same advice even today, that just doesn't hold water,
No.
in my judgment.
Yeah, that's, if that's what he said, that's alarming.
Yeah.
But in that,
Well, Ann, what can people do about this? Is it a situation where we don't have enough citizens in communities that are demanding openness in government? In other words, who's at fault here? Is it bureaucrats that want to go into closed session and know they can get away with it? Is it the Attorney General who doesn't prosecute these things aggressively? Who's at fault?
Well, ultimately, it comes back to citizens.
Yeah.
And citizens in Milton, by the way, there's another case coming up at the 4th District Court of Appeals.
In Milton, Wisconsin?
Milton, Wisconsin met for almost a year in closed session, claiming that they were going to, in the meeting agenda, talked about we're looking at an industrial park. Well, boom, when it came out after something like 9 months, it was going to be an ethanol plant. People were going like, how'd that happen? Well, it was all done in closed session. So now it's at the Court of Appeals, and so there's a potential there for reversing that decision. And I don't know what the status of the ethanol plant is, whether it's been stopped or whether there's been any kind of injunction. But citizens hired an attorney and went after the city of Milton.
But in that case, the district court went against the citizens, is that correct?
Right.
They said that this was appropriate.
Yeah, the lower level court
Right.
went against the citizens, and then they're taking it to the Court of Appeals.
Okay.
And isn't it a shame that citizens have to expend their own funds just to make sure that their government that they pay taxes to is doing things according
Yeah.
to the law?
Now, I think there's some other things you can do. I think we need a lot more training on public records, not just for city council members and county supervisors, but for citizens. So, you know, the AG's office could be doing, 20 times as much training as it's doing. I know it comes around usually in January, February, and they do their sessions throughout the state. But, these are not things you can just go to a session, and even if you're there all day, to come out and really know
Sure.
how to deal with it. And so I would say we need more training of citizens. I think we need more advocacy groups. And of course, the Wisconsin Freedom of Information Council that I represent has been very on top of all of these issues, and they've, in this case, they filed a front of the court along with the Wisconsin Newspaper Association, the Wisconsin Broadcasters. So,
In the Milton case? Mm-hmm. Okay.
so that decision will be a few months off yet, but when they make that decision, and we start having some decisions like the AG's opinion in this, and then we start building some expectations of city councils and other public bodies, that negotiating and competitive is just going to be under a lot of scrutiny.
Chuck, we've, we keep hearing from the Attorney General, and not just this Attorney General, but past Attorney Generals, that these fines, they're not really prosecutable type actions, and all it is a civil forfeiture. It's a fine. At what point, if the city kept doing this, you're going to have different city councils, obviously, because some of the components, some of the elements on your city council change every April, in a lot of cases anyway. So at what point would something more than just a 15-page opinion come into play? When would they start instituting some fines or taking some additional action?
Well, the fines, I believe, range from $25 to $300, which is, not much.
Right.
But I think the, voiding any decisions made that were done at an improper meeting would, be a way to discourage and allowing attorney's fees and expenses to people who prosecute a claim. Now, in your case, whether you didn't hire any attorneys, I don't think,
No.
but whether you incurred any expenses in whether you could be reimbursed also. But again, the actions of the public officials have to be fairly, they have to knowingly be violating the law, and maybe that, in a particular case, how do you prove that? That's really, it's hard. It is they want, I think, in the statutes and that, they say that the open meetings law is to be liberally construed in favor of open meetings, but the penalties for violation are to be narrowly construed, which is kind of, defeats the purpose, of the penalties if they're not going to be, imposed. But they narrowly, you really got to do something knowingly wrong, and in this case, they didn't feel that anyone did because they attempted to get legal advice, and they got it from Warren Kraft, the city attorney, and his advice, he felt was appropriate under the circumstance. And
Do you think this exemption could be rewritten? Obviously, there are things like when you invest public money and you agree you'll pay up to 9, but maybe you can get it at 7. You don't want to release that information to the public before you actually make your attempt to buy some securities or something like
Right.
that. I mean, obviously, there are some good reasons not to release your decisions
right.
in public. Otherwise, you just hurt yourself and the citizens too. But do you see any way to rewrite this exemption so that these people are just feeling like, there's some embarrassment, they don't want to ruin their chances of appealing to other developers and things like that? They're afraid, it seems to me, and they'd rather make the decision to close it than to keep it open and take whatever consequences there are. Is there any way to rewrite this? I think there's a need to make this across the board. If people are really worried about developers not wanting to do business with the city because,
Yeah, it's it is a difficult thing, in private industry or whatever, private business. They can keep things as private or confidential as they want, but again, when you've got a government involved, of the people, for the people, by the people, it's got to be open. But it does create, problems in in certain things, and that's the statute, section 19.85 has the, reasons. I think it's 13 reasons or something that you can go into a private meeting. Or private, closed meeting, and
some of those are good.
Whether they could
reasons,
be
but,
more, the one that the city went under was it's pretty broadly written, to deliberate or negotiate the purchase of public properties, the investing of public funds,
Right.
which they were doing, or conducting other specified public business, whenever competitive or bargaining reasons require a closed session. That's what the exemption they were going under for a closed session, and it did.
Well, at the very least, I think they ought to be compelled to have to either record those meetings or keep good minutes at them. And my understanding is they don't have to, Ann, is that right? In these closed meetings, you don't have to keep
I've been in
minutes?
some closed meetings where people were instructed not to take notes, or notes were shredded immediately after the meeting. And the problem is, once you've got a public record, then after the meeting, that is accessible by the public, or
Sure.
can be accessed by the public. So, and there may be some things that shouldn't necessarily circulate.
But doesn't
But-
a city place itself at great harm by going into closed session and not keeping minutes and not recording it if there is a controversy later on? In other words, let's say a developer takes a city to the court and says, I was promised A, B, and C in that meeting, and now they're not coming through with it.
Well, but see, that part of it should be done in open meeting, open
Should be
session.
done in open meeting.
Well, you can talk all you want in a closed meeting, but when you come out and make a decision, although that may not be entirely true either.
Yeah, they can vote on, make
They can vote
decisions
in
in a
closed
closed
session.
session, that, and I don't know how they document that,
Well,
but
that's-
I would think
They have to ultimately come back out, though, and vote on something, right?
Well, no, he's saying that you can do it in closed session.
It depends, it's limited to, very specific situations, I think, but it's all a fine line, whether,
Sure.
and, and how important is it that it be closed? It really has to be a very important reason, that is a good reason, and in some cases, in this particular case, just knowing whether he'd met his financial, requirements was not really a legitimate purpose for a closed meeting, but they did it, and maybe because of, like it said, in the embarrassment that he
Yeah.
wouldn't have had it, and he was far away, and they didn't want it to come out yet.
Sure.
But you're right. You could have the city administration preparing contracts and so forth, signing them underway, and then come back to the city council and say, well, that's not what we decided. We put some stipulations in there. So if there's no record, are those records there but just not accessible?
So how do we go about making sure then that, accurate minutes or minutes at all have to be kept in a closed session? I mean, is that something that we petition the state government, the state legislature to make changes in the laws for closed session meetings?
That might be I'm not quite sure if there is a specific method that they use, in certain, it differs everywhere or not, where they keep some
But why
minutes
would
of
they
a
not
closed
come out
session.
into open session to make those decisions? Because then you clearly keep minutes.
I mean, I think
minutes
ideally
are-
they want you to do that.
See, I
Ideally,
think-
if they have a closed session and they bring it out, what happened. But I think there are situations where they can make a decision there and don't have to.
Yeah.
I mean,
And isn't it true that the open meetings law does not apply to the state legislature? That they go into
No,
closed...
it does.
But they go into closed caucus meetings. How can that
Well,
fly?
that's an issue that really needs to get resolved. That is,
But that is true,
that
right?
seems to be a violation of the Open Meetings Act.
Well, how could they justify it as not being a violation of the Open Meetings Act? That,
And I think nobody has really pressed them on it. I mean, there's certainly been plenty of discussion in the Wisconsin Democracy Campaign and
well, it does,
so
right.
forth.
It does frustrate local officials because local officials are under more of a microscope on open meetings. But then the legislators in Madison regularly go into closed session for their caucuses. And
Yeah, the caucuses seem to be sort of a sacred thing that nobody is really, as far as I know, is not challenged.
no, and that's where the party leadership bullies the members, tells them how to vote, and yet the public is not able to see that.
Well,
It's
and they
absurd.
will have their friends in there, so
Yeah.
whoever they want to invite to come in can be at the meeting,
Yeah.
but not us who
No,
want
not
to
the
be there.
citizens. No, it's absurd. Should we move to the Miller's Bay?
Yeah, why don't we do that?
Chuck, you've been involved in a controversy in town over the decision that the Oshkosh Common Council made. It's over a year now, isn't it? Much more than a year, I believe.
Yeah, it was. I believe it was June of 2005.
All right. The council voted to allow the Otter Street Fishing Club to place a pier in Miller's Bay.
Correct.
And you're part of an organization or neighbors that claim that there was no meaningful public discussion of this. and maybe even some improper meeting. Why don't you just summarize?
Yeah,
for us what happened?
the notice of those, there was a Parks Board meeting the day before, and then the City Council meeting the next day, approving this gift of a pier and placing it at the foot of New York Avenue in Millers Bay. And that the notice was that there was going to be discussion of a donation of a fishing deck instead of a fishing pier, which the word deck is rather vague.
Yeah.
And whether people thought, well, a fishing deck, what's that going to be? But they did pass it that night at the Parks Board meeting Monday, and then on Tuesday night it went to the City Council and was passed. There was a vote to lay it over, but that vote failed. It was 3-3. One council member was missing that night on vacation, but it was a 3-3 tie not to lay it over, and then somehow they reversed themselves and voted to allow the donation of this pier, which we felt should have had more public discussion on the location. No one is really opposed to a fishing pier. It's just in this location that does not have other man-made structures. It's a more or less natural shoreline, and we're trying to keep it as natural as possible. Then the matter had to go to the DNR for a permit to allow the pier to be constructed, and the DNR, after a public hearing in October, did allow the pier to be built, and then that was appealed for a contested public hearing, and that matter is still pending, and it hasn't been scheduled yet. We expect it'll be scheduled in the next 3 months, and we're hoping, and we've been trying to meet with the Otter Street Fishing Club and the city to try to just discuss mediating a different location or trying to get an alternative location. And unfortunately, the city has said that they don't want to mediate because the fishing club doesn't want to mediate. But I don't know. We still would like them to discuss it with us, and we think it's a great gift. But it's just the location. Can't we find a better location? And but if it goes to the DNR hearing, then there's an administrative law judge who will take testimony and decide whether the pier has a negative effect on natural scenic beauty of Millers Bay, whether it affects navigation, whether it affects wildlife or fish habitat or plant life. And
Right. Well, let's back up a second, Chuck, just to go back to the beginning of this. The Parks Board approved this on a Monday. Had that been the first Parks Board meeting at which this was discussed?
yes, and it was presented, I believe, the week before. The whole proposal was presented to Tom Stefani the previous week.
Privately?
It was, I think, in a letter from Terry Wohler, who is the treasurer of the Otter Street Fishing Club, and he is a member of the Parks Board.
Member of the Parks Board.
And he had a conflict of interest acting, in my opinion.
So was it, on that Monday Parks Board meeting, was this on the agenda? Did it say something like approval of
Right, it was noticed the day,
Right.
it was adequate notice. It's just the notice was about a fishing deck.
Okay, so if you were a member of the public interested in these kinds of issues, you somehow had to miraculously know that there was going to be a Parks Board meeting on this. How would you know that?
If you were, it is posted at a location by the city clerk's office. They post the notices of the meeting and what the agenda is. And
Okay. But people, especially people who live in that area, who many people criticize them as just simply not wanting to look at the pier, whatever, it's not likely they would be roaming City Hall to find out about the first they found out about this pier was, I imagine, after the City Council approved it. Is that right?
Right. A few people found out about it at the Monday night Parks Board meeting, or some people who watched the Parks Board, which there's a.
Oh, because it happened to be televised.
I don't know if it was. I don't think it was. I guess it must have been publicized, but televised. And then it was. I got a call from someone who keeps an eye on the Parks Board and said,
Right.
did you hear that they want to build a big pier there? And I said, no, I didn't know. And then it's on tonight at the City Council, and I honestly thought the City Council would provide, more time.
Well, just common sense, yeah. I mean, but Ann, again,
Well, the other thing is, what they really should do, rather than taking a minimalist approach, post it up on City Hall, maybe put it on the website, those are minimal kinds of things. They ought to send a notice to everybody in the neighborhood and say, we're going to have a public hearing.
Well, yeah, I mean,
well, the issue, I believe, from the standpoint of the Otter Street Fishing Club, is that Menominee Park is not a neighborhood park. It's a city park. So therefore, there should be no, I'm not saying this is my view, but this has been the argument. There should be no compulsion to notify those neighbors, because it's not a neighborhood park.
Well, but let me just interject here, because when Tom Stefani, the Parks Director, came before the City Council to explain his notification process, or lack thereof, he said that Menominee Park, because of its size and stature, is not just a neighborhood park, it's a city park, and I think he even went so far as to call it a regional park, if I remember correctly. And yet he admitted that he does not have a notification process. And I thought that he was going to be a little bit more diligent in notifying neighbors, but they could never quite come up with the criteria.
This
under which
suggests
someone
to
would be
me
noticed.
that somebody wanted this to move along really quickly without much public discussion, because you can always make sure you get it in the newspaper, and I still think you need to have public hearings on those issues, because people do care about those issues.
Yes, and it's not just the people who live right across the street. It is, there are a lot of people who use the park who just appreciate having a natural landscape and having green space and not having, and there are people who are opposed to it. There is the statement, oh, it's just the neighbors across the street, but it
And this
isn't.
is a not in my backyard
Not
issue.
in my backyard, I know.
Right.
But it's, it's just that it really came too quickly, and we've tried to ask the city to reconsider it, and and we tried to ask the fishing club too, and I don't know why there can't be more discussion about it. I really don't.
Well, at one point, Chuck, I believe a couple of members of the council said they would only reconsider if it could be demonstrated that some law maybe was broken in this whole process. And you did go speak to the council.
Yeah.
And you didn't have proof that any law was broken, but you said that there was some gray area. Why don't you explain to us?
Well, there was gray area on the notice. Fishing deck versus fishing pier. It was somewhat gray, but the legality of Terry Wohler voting, being a treasurer of the Otter Street Fishing Club and being a member of the Parks Board, and then voting on the approval of this gift by his club that he was an officer of. That's an apparent violation of the state code of ethics. The state of Wisconsin has a code of ethics law for public officials that would require him to have not participated in the voting on that subject. And then
even though he doesn't, he doesn't personally profit from it, does he?
He doesn't, but his organization, because he was an officer of that organization, he is supposed to be disqualified. And then the city council took it the next day, and Mayor Castle lives across the street, and we felt that he had a potential conflict of interest, that he should have abstained because of his desire not to, I guess he wasn't opposed to it, but whether he didn't want to oppose it because he would be accused of living across the street from it, he was put in a difficult situation, having to, he had a conflict of interest, and so he did vote in favor of it, but if his vote wasn't done that day, it wouldn't have passed that night without his vote to block laying it over. His vote was critical to that.
There ought to be a justification for reconsidering something just because you didn't have adequate discussion.
Yeah, and that
And had an explicit notice at least in the agenda, that it's going to be a fishing pier at such and such a location, probably would have grabbed somebody's
Yeah.
attention. But still, in a democracy, you want to do maximum democracy,
Right.
not minimal, just what we got to do for the law.
Yeah, and this was a 48-hour process that
Right.
went through.
Yeah.
And I mean, it was a very quick decision, and but it's still not built yet. So we're still trying to change some minds, and hopefully something can happen to put it in a more acceptable location to more people. I mean, and I think that there's got to be better locations, but
Well, the whole thing, the fishing pier, the open meetings thing with Five Rivers, it's all very sad, because what strikes me about all of this is that we have a city council and other city leaders, whether they're paid employees or volunteer members on boards, who won't abstain from voting on issues, and who won't step back and say, maybe we need to get more information. They would rather just forge ahead because the city attorney says it's okay, rather than erring on the side of caution and doing what is right by appearances. And that's sad, I think.
yeah.
And very quickly, you were involved earlier this year with the Diebold touchscreen machines in Winnebago County, and didn't you come to find out that the county clerks make really momentous decisions on voting without any open meeting requirement? Isn't that right?
Yeah, because they're not a governmental body.
That
They're
is
just
what
not a
disturbing,
governmental
isn't it?
body,
The way we vote is one of the foundational principles of a democracy, and yet decisions are made we hear nothing about.
But what they don't constitute a governmental body, and they didn't, when they met to decide, it wasn't a meeting. So, so as far as I can tell, I don't know, maybe you have an opinion on that.
Yeah,
but,
I guess whether they're a governmental body or not, that could be debatable, and whether they're subject to open meetings laws if they're a governmental body.
But as a group of clerks, they're nothing. I
Even
mean,
though they're elected?
They're elected and they belong to their, county. But as a body, this is my
They're not an
explanation
official
of this.
elected body.
They're not a council. They're not a committee.
Yeah.
They're just a bunch of clerks that got together and they decided, which one do we like?
All right. Well, the hour's up, and I want to thank both of you for being here tonight, and not just for being here tonight, but for doing what you both do, because we're all very much activists on one level or another, and so thanks to both of you, Chuck and Ann, for doing what you do to help keep our government open and operating the way it should. So, and Tony, thank you. And as always, thanks to all of you at home for letting us into your homes for the last hour. We'll see you next time. Until then, take good care. Keep your eye on us. We've got our eye on Oshkosh.